Office of the Court Administrator versus Ladaga. Facts of the case. Attorney Misael Ladaga, Branch Clerk of Court of the RTC of Makati, Branch 133, requested the Court Administrator, Justice Alfredo Benipayo, for authority to appear as pro bono counsel of his cousin, Narcisa Naldoza Ladaga, in criminal case. While respondent's letter request was pending action, Lisa Payoyo Andres, the private complainant in criminal case, sent a letter to the court administrator requesting for a certification with regard to respondent's authority to appear as counsel for the accused in the said criminal case. The respondent admitted that he had appeared in criminal case without prior authorization. He rationalized that his appearance in the criminal case did not prejudice his office nor the interest of the public, since he did not take advantage of his position. In any case, his appearances in court were covered by leave applications approved by the presiding judge. Court issued a resolution denying respondent's request for authorization to appear as counsel and directing the Office of the Court of Administrator to file formal charges against him for appearing in court without the required authorization from the court. The court administrator filed the instant administrative complaint against respondent for violating Section 7B2 of Republic Act No. 6713, otherwise known as the Code of Conduct and Ethical Standards for Public Officials and Employees. The issue of the case is whether or not Attorney Misael Ladaga engaged in private practice. The court ruled that no, Attorney Ladaga did not engage in private practice. Respondent is charged under Section 7B2 of the Code of Conduct and Ethical Standards for Public Officials and Employees, which prohibits civil servants from engaging in the private practice of their profession. A similar prohibition is found under Section 35, Rule 138 of the Revised Rules of Court, which disallows certain attorneys from engaging in the private practice of their profession. However, it should be clarified that private practice of a profession, specifically the law profession in this case, which is prohibited, does not pertain to an isolated court appearance. Rather, it contemplates a succession of acts of the same nature, habitually or customarily holding one's self to the public as a lawyer. Based on the foregoing, it is evident that the isolated instances when respondent appeared as pro bono counsel of his cousin in the criminal case does not constitute private practice of the law profession contemplated by law. Nevertheless, while respondent's isolated court appearances did not amount to a private practice of law, he failed to obtain a written permission therefore from the head of the department, which is this court as required by Section 2, Rule 18 of the Revised Civil Service Rules. Respondent failed to obtain a prior permission from the head of the department. The presiding judge of the court to which respondent is assigned is not the head of the department contemplated by law. Attorney Ladaga was reprimanded with a stern warning that any repetition of such act would be dealt with more severely.